Ladies and gentlemen, we're going to get started in just probably 2 or 3 minutes, but there is a sign-up sheet. If anybody would like to speak on any of the bills, there's a sign-up sheet located here up front. Where is it? It's up on the podium. So if anybody would like to speak to any of the bills, please sign up on the sign-up sheet. Thank you. We'll get started in 2 or 3 minutes. All right, ladies and gentlemen, it is 11, and we do like to start on time. So I'm going to go ahead and call this Judiciary Juvenile Committee meeting to order. First up will be Senator Enavatarte. Welcome.
Oops, sorry.
Introduce yourself to the committee and tell us about your bill.
Thank you, Chairwoman. It's always great to be with you. And Jesse Weatherington's here. He's been working on this bill with us. I'll let him chat in a second. Senate Bill 110, it's pretty much a fairly straightforward bill dealing with Georgia's open-ended definition of neglect. And basically just trying to make sure that the definition is more specific and fair and giving families across the state notice that their right to let children just do some basic things like walking, running, going to the grocery store, outdoor play, engage in independent activity is okay. Senate Bill 110 allows parents to make family decisions and determine when their child is sufficiently mature based on physical condition, mental abilities, to avoid substantial risk of physical harm. The bill also clarifies that neglect is the denial of necessary care to a child, creating an environment that is obviously injurious or his or her welfare. This tightening definition of neglect comports with the public's understanding that the state should not intervene in a family life unless the parent's actions or omissions cause a serious risk of harm to the child that is obviously reasonable to a parent. Current law allows authorities to label parents a child neglector based on their own moral judgments without families are getting swept up in the criminal justice system or child welfare systems for giving their kids, either by choice or necessity, some appropriate freedom and independence. Investigating families did not endanger their kids and simply gave them some reasonable independence results in an increased caseload and is a huge expense for Georgia taxpayers. Basically, in a nutshell, we just think that this is a great bill for parents to really define, what's good for themselves, what's good for their community, from a personal responsibility standpoint. And with that, I'll answer any questions.
All right. Members of the committee, I'm just going to call you by your number. So number 13.
Thank you, Madam Chair. Thank you, Senator, for bringing this bill. This is the case, I assume this came out of the case up in McKaysville with the mother who was arrested because her child was walking I happen to be very familiar with the area. It's a pretty rural area. And I thought I was really surprised by the arrest. I know DFACS has some guidelines for ages that kids should be alone or babysitting younger siblings. Does this change that, or is this kind of an additional guidepost for law enforcement?
Do you want to take that? Thank you, Madam Chair, members of the committee. My name is Jesse Wethington. I'm here on behalf of Let Grow, which is a national not-for-profit child advocacy organization which advocates for bills promoting childhood independence. So the DFACS guidelines, I think they establish like the age of 14 is where a child could be responsible for babysitting a sibling or something like that. This bill, I think, is more just narrowly tailored to what we would characterize as providing a safe harbor for the definition of neglect. So I don't know necessarily that it would affect the guidelines. I believe DFACS is here and they could speak to that. We've had several communications with them about the content of this, and they didn't raise any issues with us. I don't want to speak for them, obviously, but we don't believe that it would necessarily supersede those unless there was some specific instance.
Thank you for bringing the bill, Senator.
Okay. All right. Thank you. 27. Yes.
Thank you, Madam Chair. I'm looking at the language imminent risk on line 14 and on line 16. Tell me if imminent risk is a change in the standard in the existing case law. I'm trying to figure out what is the case law today in terms of risk, and to what extent does the entry of the word imminent risk change the case law, Supreme Court case law?
So Representative Aller, I'm not an attorney, as you know. You were very well schooled in these issues. There was reference in the initial version of this to a standard, which was removed because that standard was undefined. Not aware what the current case law definition is. I think the effect of this statute would be that would sort of be defaulted to the judgment of the legal guardian and the child's maturity level at that point.
Well, imminent risk, I think, is language used in the incapacity in terms of 1013, somebody taking them into, so we fiddled with that language in other contexts, and it's quite high standard in the context of mental incapacity. So that's why I'm noting that language. So nobody can tell me whether the Supreme Court uses anything close to the term imminent risk in cases?
I cannot dispose of that question for you, ma'am.
Thank you.
Can any members of the community, I know we have several folks out there from our juvenile judges and the Division of Family and Children's Services, so does anybody out there know about the standard of imminent risk and how it's defined in case law? Nope. Okay. Any other questions? Okay. Y'all are letting them off too easy. Y'all must be friendly, or maybe y'all are just tired. But, okay, so we have before us Senate Bill 110, LC 49225-2S. Okay, there's a move and a second to pass. Is there any discussion? Seeing none, what is the will of the committee? All those in favor of passing with a do pass recommendation for Senate Bill 110, please signify by saying aye. Any opposed? All right, congratulations, Senator.
Thank you.
Thank you.
And you will need a rules form, and I will get it to you right after the meeting.
Okay. Thank you.
All right, Senator Calzert. Senator?
Thank you, Madam Chair. Pleasure to be with you this morning.
Yeah, thank you. Introduce yourself to the committee and just tell us a little bit about your bill.
All right, I'm Bill Calcert, and this is a bill for the Department of Community Health, their Aging Services Division. When you have minors or incapacitated adults that are generally elderly, sometimes we'll have to appoint a guardian to take care of either their person or their property. Guardian was the term traditionally used interchangeably, really, for both looking after a person's affairs and also their finances. Generally, people that can't care for themselves. There's a pecking order, so to speak, of who can be appointed by probate courts to serve that role. Ordinarily, it's next of kin. It's somebody that's got an interest in them and a relationship with them, but the guardian of last resort is a county guardian that's appointed an individual on behalf of the county that'll step in and serve when there's nobody else to come forward and serve as a guardian for a minor or an incapacitated adult. What happened is we used this term kind of interchangeably with conservator. When they revamped the code some years back, they didn't designate the difference between a guardian that looks after a person's personal decision and a conservator that protects their money or their finances. And you can imagine with a minor, that would last till they're 18 years old, then the money's turned back over to the child. With people with dementia or incapacitated seniors, it essentially, you look after them financially until their death, and then it's distributed to their heirs. This is just to correct a glitch in the law that we did not change the term county guardian to add county conservator. The same person now, as county guardian, is serving in both roles, but it's more appropriate to call them what they are, a conservator. So that's why this is multiple pages. It's just going through different places in the code and substituting county conservator where appropriate, where right now it's referencing the county guardian. So it looks like a much longer bill than it is, but that's all it's doing. It's getting the nomenclature right. Because if you don't have a county conservator, the state ends up having to serve that role, and they're not really equipped or functioned to do that because a conservator might be there for many, many years. You know, if somebody's in their 60s or 70s and they're incapacitated, have dementia for other reasons, and the county or the state has to step in and manage that money and supervise it, that's a burden, and it's best left up to a county guardian. So we're going to call them a county conservator where they should be. I think
Okay.
that lays
All right.
it out.
Thank you for that presentation. Members of the committee, do you have any questions of the sponsor? We are chugging along today.
All
Seeing
right.
no questions.
Very efficient.
There's a move. Is there a second? Several seconds. All those in favor of a due pass recommendation for Senate Bill 98 LC 570226S. All those in favor, please signify by saying aye. Any opposed, like sign? Sir?
Madam
you-
Chair, Representative Scoggins has agreed to carry this in the House if I need to let you know that, or
Okay.
I'll put it on the appropriate forms.
Okay.
Thank you so
All right.
much.
I appreciate it. Thank you. Ladies and gentlemen, that concludes our agenda for today. I appreciate your attendance. I will make sure that everybody gets turned in for the committee. Thank you. Bye-bye. We are adjourned.